Okay, welcome, and thank you for joining our webinar, The Most Interesting Franchise Law Developments of 2018. I am Mesa Frank, and I am here with Julia Colarusso and Quentin Wittrock. We are all shareholders and litigators in the Franchise and Distribution Practice Group here at Gray Plant Moody, and we are all current and former editors of the GP Memorandum, which is our group's monthly publication that summarizes interesting cases and developments in franchise law. This webinar is one of our group's continuing series of webinars, and we encourage you to look for more webinars in the future. So today we'll be discussing a few of the year's most interesting franchise law developments. There are a number of interesting cases and issues this year, certainly more than we could fit into an hour-long presentation. And so today we're going to focus on just a few of the most interesting topics, including issues arising from the use of no-hire or anti-poaching provisions, various joint employer issues, arbitration cases, and distribution cases. If you have any questions as we're talking, please feel free to type them in the box, and we'll try to either address them throughout the presentation or at the end. And if you work at one of the companies involved in a case that we discuss and you'd like to comment on it, please feel free to type that in the box too. Following this program, within the next day or two, we will publish the recorded audio of this presentation and the PowerPoint on our website. So if you'd like to refer back to it, you will be able to find it there. So Quentin and another one of our colleagues, Carl Zwissler, presented a webinar on anti-poaching back in March. That presentation is available on our website, and I highly recommend it to you for more background on the topic. I'm going to try not to repeat their presentation here. But as they discussed, many franchise companies have recently come under fire for provisions in their franchise agreements that prevent franchisees from hiring or recruiting employees from each other. These are known as no hire or no switching or anti-poaching provisions. The provisions might take various forms. They may vary in the types of employees that are covered, in the time frames that they cover, or in the type of stores covered. For example, they might cover only franchise outlets, or they might include company-owned stores. But nonetheless, there has been a lot of activity around the use of these provisions. So as we mentioned in our previous webinar, in early 2018, the Washington State Attorney General, Bob Ferguson, began investigating anti-poaching practices. He issued civil investigative demands to several franchise brands, starting first with quick service restaurant chains. And over the summer, he began announcing settlements. Ferguson negotiated assurances of discontinuation, in which franchisors agreed to remove no poaching clauses from their franchise agreements on a nationwide scale. He announced settlements with 7 fast food chains in July. In August, he announced an additional 8 settlements and an additional 8 settlements in September. Also in September, Ferguson announced that he was expanding his investigation to industries beyond quick service restaurants. Then in October, he announced settlements with 7 chains, including the first brands outside of the QSR industry. On November 21st, he announced settlements with 4 more companies, bringing the total to 34. His office has said that the investigation continues in other industries, including those listed on the slide, and hotels, home health care services, cleaning services, convenience stores, tax preparation services, parcel services, electronics repair services, child care, custom window covering services, and travel services. And in one case, a company, Jersey Mike's, refused to enter into such an agreement, and it has since been sued by the Attorney General in the King County Superior Court. In that case, the Attorney General has asked the court to order Jersey Mike's to stop using anti-poaching clauses in its current and future contracts with franchisees, both in Washington and nationwide. The Attorney General claims that Jersey Mike's could face civil penalties, and he is also seeking to recover the costs and fees for having to bring the litigation. So according to Attorney General Ferguson, this is the only fast food chain in Washington that still has a no poaching clause in its agreements. And then there have been some additional investigations. In July, the attorneys general of at least 10, possibly as many as 14 states and the District of Columbia announced that they were also investigating the use of no poaching agreements at least 8 different fast food franchise brands. They are seeking assurances of discontinuation similar to those obtained by the Washington State Attorney General, but in their states only. One other development, the DOJ Antitrust Division has sought information from the IFA concerning the use of no poaching provisions in the franchise industry. There has also been some proposed legislation on this topic. At the end of February, Senators Cory Booker and Elizabeth Warren proposed legislation, which they call the End Employer Collusion Act, that would make no hire and no poaching clauses in franchise agreements illegal. Congressman Keith Ellison also introduced companion legislation in the House in April. So Senators Warren and Booker sent a letter to nearly 100 CEOs of large franchisors in July asking them to abandon the use of no poach agreements in their franchise agreements. And in June, they also questioned the DOJ and FTC regarding a policy which is known as the safety zone that allows employers to exchange detailed wage data without violating antitrust laws. So we will certainly continue to see where that legislation goes. Finally, there have been a number of class action lawsuits filed against franchise brands related to their use of anti-poaching provisions. We had discussed some of these in our prior webinar, and since we last reported on them, 3 of these class actions have moved through the motion to dismiss phase. Each of the plaintiffs in these cases brought claims under the Sherman Act, Section 1, as well as related state law antitrust claims. The plaintiffs essentially claim that the franchisors and their franchisees are engaged in a scheme to reduce competition for workers and to depress the workers' wages. So just to quickly summarize the legal landscape, under antitrust law, the classification of the relationship between the parties to a no-poaching agreement is important. It might be either horizontal or vertical or a sort of dual distribution arrangement, which might arise when a franchisor, for example, has company-owned outlets that operate at the same level as its franchisees. But the classification is important because it impacts the mode of antitrust analysis that might apply to the claims that the plaintiffs bring. So a horizontal restraint would typically an agreement between competitors. And for horizontal restraints, the courts would generally apply a per se analysis. In contrast, for vertical restraints, which tend to go up and down the distribution chain, the rule of reason would apply, which is a more lenient standard. There's also an intermediate standard, which is known as a quick look analysis, but sometimes described as a form of rule of reason analysis. But in these class actions brought against these franchisors, the plaintiffs have alleged that either the per se or quick look analysis applies. And this is important because under these standards, the plaintiffs don't need to prove up all of the typical elements required under a rule of reason analysis. For example, market power or the relevant product in geographic market. So the franchisors, in their motions to dismiss these cases, have argued that because the no poaching provisions are, essentially vertical agreements between franchisors and franchisees at, different levels of the distribution chain, and because these no poach provisions are intra-brand restraints, meaning within the same brand rather than restraints between competitor brands, the franchisors argue that the rule of reason analysis should apply. And because the plaintiffs in each of these class action lawsuits did not allege the elements necessary under the rule of reason analysis, like market power or the relevant market, the franchisors have argued that the complaint should be dismissed. Well, in all three instances, the courts disagreed. The first case is a McDonald's case, Deslandes versus McDonald's. In that case, the court denied McDonald's motion to dismiss and held that the quick look analysis might apply, but did say that the restraint was not unlawful per se. Briefly, the court found that there was a horizontal restraint at issue here. The no poaching provision was a horizontal restraint. But in part, this was because the no poaching provisions also covered company-owned stores, meaning that the restraint applied between franchisees and stores owned by the franchisor. The next case is Butler v. Jimmy John's. In that case, the court denied Jimmy John's motion to dismiss and held that any of the three types of analysis might apply, per se, quick look, or the rule of reason. In the Jimmy John's case, the court found a horizontal restraint, but under an orchestration theory, which is also sometimes known as a hub and spoke theory, which essentially means that even though the no poaching provision was contained in the vertical agreement between franchisor and franchisee, the franchisor essentially convinced the franchisees to enter into no poaching agreements with each other. Now, one relevant fact in that case is that the no poaching provision made each franchisee a third-party beneficiary of the other franchisees' restraints. So that likely contributed to the court's finding of horizontal restraint under an orchestration theory. And then the most recently decided case in November involved Cinnabon. In that case, the court also denied Cinnabon's motion to dismiss, and it held that the quick look analysis might apply, but that the restraint was not unlawful per se. And the court in this case essentially relied on the McDonald's case. So, each of these cases was decided on a motion to dismiss. That standard, gives great discretion to the plaintiff's allegations. So certainly we will follow these cases and see, what happens if and when they go through full discovery. There are several other pending class action cases, at least 10, possibly more. A few of these cases have motions to dismiss pending, and we'll be awaiting decisions on those. And then there are, some cases that have been filed but have not yet progressed to the motion to dismiss phase. But our group represents companies, in the Washington State Attorney General investigation, in the investigation by the other attorneys general. We also represent companies before the DOJ and in these class action lawsuits. So we will certainly be monitoring, the developments in this area of law, and we will report on them in the GP memorandum or elsewhere as appropriate. And now I'll turn it to Julia, who's going to talk about joint employer issues.
All right. So the next set of developments we're going to discuss fall under the general umbrella of control-related liability of franchisors. I know it's everyone's favorite topic. Under that umbrella, we're including anything that relates to a franchisor's liability for the acts of franchisees or franchisees' employees, particularly in the employment context. And obviously, this issue has been a big issue for many years. And in 2018, we saw developments both at the National Labor Relations Board and in case law outside of the NLRB. And there's just a ton we could cover here, and really the topic could fill its own webinar. So in the interest of time, I'm going to focus primarily on joint employer developments at the National Labor Relations Board because there were many this year. And then I'd also like to discuss a recent summary judgment decision out of the Southern District of New York that provides a pretty thorough analysis of the joint employer issue in the wage and hour context. I think it's a really detailed, instructive decision that will be cited fairly frequently going forward. In the PowerPoint presentation, I've included citations to several additional cases that I don't think I'll probably have time to get to today. These are all cases that involve either allegations of a joint employer relationship between a franchisor and its franchisees, or allegations that a franchisor was vicariously liable for the actions of its franchisees, or allegations that a franchisor misclassified its franchisees as independent contractors. And all of these cases are definitely worth a read. On my favorite podcast, they always start out whenever they're going to discuss a really big, newsworthy topic, they always say, let's get into it. And that's how I feel about joint employers. So let's get into it. And I'll start off with the unusual set of events that unfolded at the NLRB this year. And I think it's important to kind of briefly recap how we got to this point. And of course, that means that we have to go back to the big decision in Browning Ferris Industries in 2015, which expanded the kind of business activities that could be found to create a joint employer relationship. Prior to Browning Ferris, for many, many years, when determining when two or more entities would be considered a joint employer under the National Labor Relations Act, the NLRB looked at whether an entity possessed and exercised direct and immediate control over things like hiring, firing, and setting schedules for employees. So it was the direct and immediate control standard. And in Browning Ferris, under the Obama administration, the board adopted a new standard where even if an entity had never exercised control over the terms and conditions of employment, the board would also consider whether that entity had exercised indirect control through an intermediary or had reserved the right to do so. So in other words, under Browning Ferris, two entities could be found to be joint employers based on the mere right to control terms and conditions of employment, regardless of whether that right was actually exercised. So I think, as we all probably know, the Browning Ferris decision generated a great deal of uncertainty in the franchise community. There was considerable concern that under Browning Ferris, the typical brand standards that franchisors typically employ to protect their trademarks might arguably lead to a joint employer finding. And I should mention kind of the significance of a joint employer finding under the National Labor Relations Act is that a joint employer under the Act can be compelled to bargain with employees who unionize, and the joint employer can also be held jointly and severally liable for unfair labor practices. So now we fast forward to December of 2017, not quite into 2018 yet, but this is after the Trump administration took over and the composition of the NLRB changed. And at that point, a new board majority expressly overruled Browning Ferris in the High Brand Industrial Contractors decision. And so basically, High Brand reinstated the joint employer standard that had been in place for decades before Browning Ferris. Okay, so now we finally move into 2018, and the big development this year came on February 26, 2018, when the NLRB vacated the High Brand decision. And it vacated the decision after its Inspector General issued a report concerning the participation of one of the board's members in the High Brand decision, and basically the IG had concluded that the particular member, William Emanuel, should not have participated in the High Brand decision because of a conflict of interest that resulted from the fact that his former law firm had represented one of the parties in the Browning Ferris case. And it's interesting because he obviously didn't participate in the Browning Ferris case, but the IG concluded that the High Brand decision was essentially a do-over for the Browning Ferris parties. So really what that meant was Browning Ferris was reinstated. High Brand did file a motion for the NLRB to reconsider its order vacating that initial December ruling, but in June of this year, the NLRB denied that motion. So it reaffirmed the fact that member Emanuel was and is disqualified from participating in the Highbrand case. Where this leaves us is that for now, Browning-Ferris is still the law of the land, meaning that indirect or potential control over employees' working conditions could still be sufficient for finding a joint employer relationship. And now we move into May of this year, when the NLRB announced that it was considering rulemaking to address the standard for determining joint employer status under the National Labor Relations Act. And the NLRB did go ahead in September and issue its proposed rule for notice and comment. And really, under the proposed rule, it would reinstate the traditional joint employer standard that Browning-Ferris had ended in 2015. So we'll have to wait and see how the comment process plays out. The comment process was initially set for 60 days, and it has now been extended through the 13th of this month. The mere announcement by the NLRB that it was looking into rulemaking prompted congressional inquiries. So I think we can probably expect to see a fairly long rulemaking process here, and possibly some public hearings and some political hurdles along the way. So we'll just kind of have to wait and see how it plays out. Another component to all of this is that following the Browning-Ferris decision by the NLRB in 2015, Browning-Ferris, the party, had appealed that decision to the D.C. Circuit. And then after the initial decision in Highbrand in December of 2017, the D.C. Circuit remanded the Browning-Ferris case back to the agency at the NLRB's request. And then, after the decision in Highbrand was vacated on April 6, 2018, the D.C. Circuit took the rather unusual step of recalling its remand. So it reinstated the appeal, and that appeal has been fully briefed and argued and remains pending. And to the extent the D.C. Circuit rules on the merits of the joint employer issue, that could also obviously have an impact on the joint employer standard at the NLRB. So I think what Browning-Ferris and Highbrand kind of showed us this year is that the standard promoted by the NLRB can change with each new administration. And I think it's fair to say that a lot of people in franchising would like to see a legislative solution to this issue to try to bring some clarity and consistency to it. There has been some movement on the joint employer issue in Congress in 2018, but certainly not enough to suggest that we'll see a new joint employer standard signed into federal law anytime soon. I'll mention a couple of bills that have gotten some attention. There was the Save Local Business Act, which would have reversed the decision in Browning-Ferris by restricting joint employer liability to businesses that exert direct and immediate control. That bill did pass the House in November of last year, but this year in 2018, it failed to attract support from Democrats in the Senate and basically stalled there in the Senate this year. More recently, at the end of August, a bill known as the Trademark Licensing Protection Act was introduced in the House, and the initial publicly released draft of the bill is very short. It's barely 2 pages, and it would amend the Lanham Act so that the licensing of a trademark and related brand controls cannot be construed as establishing an employment or principal agent relationship between the owner of the mark and the licensee. So essentially, this law would make it so that brand controls would not be evidence of joint employer status in federal or state employment litigation. Given that Democrats now have control of the House, it's hard to see a joint employer law like this one getting much traction in Congress over the next year, but as always, we'll kind of have to stay tuned to see how this all unfolds. And while we're on the topic of the NLRB, I just want to mention one other development, and so I wanted to talk quickly about the McDonald's case, which has been pending before an administrative law judge at the NLRB for really the last several years. The litigation against McDonald's arose when employees of certain McDonald's franchisees complained that their supervisors had retaliated against them for participating in what's known as the Fight for 15 demonstrations, and also for trying to unionize, an effort that began in 2012. And the case has been seen as an important test of how Browning-Ferris might apply to franchisors. In 2014, the then general counsel of the NLRB, who was an Obama appointee, investigated the charges that the employees were complaining of and authorized complaints against McDonald's and franchisees in cities across the country. And then all of those complaints were eventually, or most of the complaints were eventually consolidated. And the general counsel's theory at the time was that the franchisor of the McDonald's system was jointly and severally liable for all of the alleged unfair labor practices on the grounds that it is a joint employer of the affected workers, and that the franchisor had been heavily involved in coordinating the franchisees' response to the Fight for 15 campaign. And the hearing before the ALJ opened back in 2015, and I think to date there's been like 150 days of hearing completed. Earlier this year, the new NLRB general counsel, who is a Trump appointee, sought and obtained a stay of the proceedings so that he could engage in settlement talks with McDonald's. And in March, McDonald's and the general counsel filed motions for the ALJ to approve proposed settlement terms that they had reached. Among other things, the proposed settlements would have resulted in payment of back pay to the affected workers and the establishment of a limited time settlement fund that would compensate employees for future instances of some of the retaliatory actions that are the subject of the consolidated complaint. The settlements did not include any admission regarding McDonald's alleged joint employer status. So the real update here is that in July, the ALJ issued an order denying the motions for approval of those settlement agreements. And the order is 40 pages long, and it goes through the entire procedural history of the case, which is quite complicated. So I'm going to spare you all of the details. But essentially, the ALJ concluded that the settlement was not reasonable in light of a few different factors, including the size of the case, the stage of the proceedings, the resources that had been expended in the hearing to that point, some of the particular terms of the proposed settlement, and the fact that the settlement would not, in the ALJ's view, conclusively end the litigation. The case is significant because a joint employer finding would mean that McDonald's would share responsibility with the franchisees for the alleged labor law violations and would be obligated to come to the bargaining table if employees were to unionize. The ALJ gave the parties the option of either filing a request for permission to appeal her decision to the members of the NLRB, or to kind of prepare for the end of the proceedings. And McDonald's has filed a request for permission to appeal. So this is another area we'll be keeping an eye on in the coming year. As I mentioned at the outset, there are a bunch of significant joint employer decisions outside of the NLRB context, and I want to quickly skip ahead to one of them, and it's the In Re Domino's Pizza case out of the Southern District of New York. It's a significant decision because, as far as I'm aware, it's the first summary judgment decision from any district court in the Second Circuit to address the issue of whether franchisors and franchisees may be joint employers in the wage and hour context. So this case arose after the plaintiffs filed 3 putative class actions against various Domino's franchisees for a host of wage and hour violations, and they also sought to hold Domino's liable as their joint employer under the Fair Labor Standards Act and the New York labor law. And following limited discovery on the joint employer issue, Domino's moved for and was granted summary judgment in full. And the court's decision is pretty detailed, and I think it's instructive for any company facing similar claims. The key holding in the case is that Domino's did not exert enough formal or functional control over the franchisee's employees to warrant joint employer status. So that's the standard that the court was applying, formal or functional control. And the court went through a variety of factors that touched on both of those components. So I'll just briefly run through kind of what some of these factors looked like. The court first looked at whether Domino's had the power to hire and fire employees. And the plaintiffs asserted that Domino's exercised control over hiring by requiring franchisees to run criminal background checks on proposed employees with an approved vendor, and by limiting the eligible candidates that franchisees could hire to those who passed those background checks and also to those who had not worked at another Domino's franchise. And the court essentially concluded that even despite those facts, the decision as to which qualified applicants to hire fell squarely with the franchisees. So even though Domino's may have been providing some guidance in the hiring process, that wasn't enough to show that Domino's actually had the power to hire those employees. Similarly, there was no evidence before the court that Domino's had the power to fire the employees. There was some interesting evidence in the record showing some instances where representatives of the franchisor may have contacted franchisees at various points in time to request or verify that some disciplinary measures were carried out. But the evidence also made clear, according to the court, that the ultimate disciplinary measures were carried out by the franchisees alone, and that was the dispositive fact for the court. There was also no evidence that Domino's controlled the plaintiff's work schedules. According to the court, simply determining when a certain job would be performed was not tantamount to determining which employee would actually perform that job at a particular time. So the fact that Domino's may have exercised some control by dictating store opening hours and minimum staffing requirements wasn't enough to kind of move the needle from typical brand standards to actual employment control. And the plaintiffs also argued that by conducting regular inspections and on-site visits and by addressing customer complaints, Domino's actively supervised the working conditions at their franchises. And the court acknowledged that Domino's could exert significant influence on franchise owners through the parties' franchise agreements, but noted that the fact that the franchisor had to resort to economic and business relationship sanctions to motivate a franchisee to implement service changes actually underscored the franchisor's lack of direct authority or control. There was also no genuine dispute that the franchisees and not Domino's determined the rate and method of payment of employees at the franchise stores, and the fact that Domino's could access certain employment information through its point-of-sale system and that employees' employment records were subject to audit did not demonstrate that Domino's actually maintained those records. So in the court's words, mere access was not the same as maintenance. The court further found that Domino's did not exercise functional control over the franchisee's employees. The court found that Domino's did not own the franchise premises or equipment used by the employees, and the fact that Domino's approved franchisees' leases and required the use of certain equipment did not amount to control of the actual premises. So the key takeaway from the case is that franchisors can influence certain business decisions that might bear on certain conditions of employment without necessarily being deemed a joint employer. And again, the key is that the franchisee must ultimately control hiring, firing, wage payment, and other employment conditions, as well as the functional work environment. And finally, I wanted to move away from joint employer for just a brief moment to mention a noteworthy decision out of California dealing with the classification of workers. And it's not in the slides, unfortunately, but the site is 416 P3D1, and the case name is Dynamex Operations v. Superior Court. This is really just my attempt to keep you engaged at this point by making you take notes. The decision was issued in May of this year, and it's significant potentially because the California Supreme Court adopted a new standard for classifying workers as independent contractors or employees So under the new standard, there's a presumption that a worker is an employee, and the burden is actually on the hiring company to establish otherwise. And I should mention this was not a franchising case. The issue in Dynamex was the proper classification of delivery drivers as employees or independent contractors for the purpose of California's wage orders, which deals with protections for minimum wages, overtime pay, and rest breaks. So it's not entirely clear at this point that this case will really be applied in the franchising context, but I wanted to mention it because it is a decision by the highest state court in California, and the court adopted what's been called the ABC test for determining independent contractor status that has been used in several other jurisdictions. So again, it's a case that we'll kind of have to keep our eye on just to see how lower courts in California develop the ABC test and to see if it's actually applied at all in the franchising context. So with that, I'm going to turn it over to Quentin so he can take us through our final topic.
Okay, thanks, Julia. We will talk next about a third issue that historically has been a hot button, a political issue like the issues you and Mesa talked about, and that is arbitration, which may be at the peak of its political hot buttonness, if that is a phrase. We give you in the slides 7 cases. They're on slides 19 through 21. And the important fact, I won't talk about each of these cases, but one thing that comes through in all 7 cases is the result. They all uphold the arbitration issue that was being fought about. For example, the right to have this case arbitrated rather than heard in court is upheld. The breadth of the arbitration clause is deemed to be broad enough to cover the dispute at issue. The power of the arbitrator is deemed to be powerful enough for the arbitrator to have reached the result, despite the fact that the aggrieved party doesn't like it. And the arbitration clause also overcomes state laws that were alleged to overcome the arbitrability of the case. So what's interesting about these cases is that where arbitration has become politically unpopular, particularly as to arbitration clauses in consumer contracts, or especially arbitration clauses in employment contracts. And now we have employers racing to issue press releases that they're not going to have arbitration in their employment agreements anymore, and they're not going to force their workers to arbitrate. While it's politically unpopular to have arbitration, courts still uphold arbitration very strongly. As you look through the GP memo, which we did in getting ready for this webinar today, we couldn't help but be struck by the fact that courts regularly uphold the arbitration. So now for you as franchisors or as operators of any kind of a business, it is a business decision whether you have and include arbitration clauses in your contracts, and if so, how to draft those clauses to make for a proceeding that goes the way you want it to go. The next case I will talk about a little bit because it went all the way to the United States Supreme Court, and it's another arbitration case called Epic Systems Corp. Versus Lewis. It's on slide 22. I don't know how many punny headlines I saw after this case was decided. Every law firm in the country wrote an article and put it on their website about the epic decision that had been issued by the United States Supreme Court. And it really is fairly important. This, however, was not a franchising case. It was an employment case. And the result of the case is, according to the United States Supreme Court, employers can require their employees to individually arbitrate their employment law claims. This is something that's called a class action waiver. You can force an employee to sign a contract that contains a waiver by the employee of the right to proceed alongside any group of similarly situated employees, and the person has to arbitrate their claims individually. So again, this was an employment case, but I think given that employment is the apex of the political dispute about arbitrability, I think even more so in franchising, the class action waiver would be upheld. And in any kind of a business case where it is more a business-to-business contract, the chances that it will be overturned are very small. The same rationale should apply to any class action waivers, and so I think they are still safe. You may be wondering, as a result of all of this hubbub about arbitration, if you should continue to have arbitration or whether it's even legal to have arbitration clauses anymore. It is. It's as strong as it ever has been from a legal standpoint. And so then it becomes an individual decision for you whether you want to include that from a business standpoint. So that is the most interesting developments in arbitration law during 2018. And I'll move now to distribution. That's my own subspecialty, and I personally feel very strongly about distribution. Represent manufacturers in their dealer and distributor cases, including antitrust litigation and advising. And this is where the cases come up, and I'll admit it, I'm the one that picked this next case to be there because it was my own case, Tri-State Bobcat versus Finn. And I won't talk about it in depth, but it's cited on slide 23, and it's a good example of a termination or a non-renewal case. And termination and non-renewal disputes are the most prevalent in both franchising and distribution. So like in franchising, state statutes regulate whether good cause is needed, whether notice is present, and whether termination or non-renewal was gone about in a proper fashion. That's what happened in the Tri-State Bobcat versus Finn case. In that case, the court found that the non-renewal or termination, as the case may be, was properly done and was legal, and that the manufacturing company won. In the Pella Products versus Pella Corp case, I guess it all comes together a little bit, the employment topics we were talking about and distribution. And here it was most interesting of the distribution cases, I guess, and that involved a situation where the owner of the business or the person that was running the distributor was alleged to have engaged in sexual misconduct with employees at his company. And so when the manufacturer, Pella, in this case, found out about this, they sought to terminate the distribution agreement, much like a franchisor would seek to terminate a franchise if something like that happened. Now, this arrangement had two different contracts between the manufacturer and the distributor. One of them was a wholesale contract and one was a retail contract. And in that one, it turned out to be what was in the contract determined the outcome of the case, because under the wholesale contract, the termination of the distributor was upheld, and the distributor was not able to get an injunction to block that termination, but the distributor was able to get an injunction to block the termination under the retail contract. And so, like with a lot of franchising cases, these are business cases governed by contracts, and they come out based on how well the contract covers the situation at issue. And since most franchises are retail operations, this case may be of interest to all of you in the unfortunate event that this type of misconduct occurs and you want to terminate someone in your system. you'll need to look at your contracts to make sure they allow termination in that system. And then the court, in this case, ruled that if the contract allowed termination for that kind of activity, then that was all the court needed to see. But barring a contract that provided for termination that covered that kind of a situation, there was not a termination allowed, at least a preliminary injunction was granted to block the termination. Another subgenre of cases that comes up in distribution all the time would be the antitrust cases that arise in the manufacturer-dealer-distributor relationship. And these also, of course, arise in franchising, and the same principles apply. The antitrust cases in distribution this year focused mostly on exclusive dealing. We have a couple of cases on this next slide, Hip Hop Beverage and Roxol versus Armstrong Industries. In the first case, the Hip Hop Beverage case, it had to do with energy drinks, and the manufacturer had exclusive contracts with brokers, requiring the brokers only to deal with the Monster energy drinks and not to carry its competitors' drinks. And the distributor said, wow, that's hurting me badly, but the distributor was allowed to get away with that. In that case, the exclusive dealing was allowed because there was no dominant market share that the manufacturer had in that case. When you think about the other brands that are available, like Red Bull and other brands, there was nothing that allowed the manufacturer to monopolize the market for energy drinks by having these exclusive contracts. And that is the test, whether you are tying up the market. And in franchising, almost nobody has market power. In fact, I don't know of anyone that has ever been found to have market power in franchising, because even the biggest of the big, Subway or McDonald's, they have many competitors, and they don't have market shares in their submarkets, however you define them, that could possibly give rise to antitrust claims being successful for dominating their markets in any way. So we'll move on to another more miscellaneous distribution case. It's a breach case, and it was against Walker Stainless Equipment. This was a case that shows the danger of exclusive territories. There, the manufacturer had given a broker exclusive rights, distributor exclusive rights to distribute in Latin America. And in the face of that contract, the manufacturer, which probably was the one to draft it itself, sold direct into the territory. And for selling direct into that territory, a judgment was had against the manufacturer for doing that, which, shows the simple principle that if you draft contracts, you have to abide by your contracts. And if you give someone an exclusive territory, and you see this a lot in franchising, you give someone an exclusive territory, there may be fights about what that means and whether you can put another franchisee right on the edge of that territory, or you can ring that territory with other stores, or whether you can open a company-owned store or somehow through the internet or otherwise sell direct into the exclusive territory that you gave someone. So the last case that we will cover today, and again, if you have any questions, feel free to be typing those in the chat box for us, because it looks like we will have some time at the end, is this case against KFC. And I thought this was the most interesting franchise case in a unique category. Here, the franchisee was forced to stop marketing his KFC chicken as halal, and that means prepared in accordance with Islamic laws and customs. The franchisee had opened several stores, all in areas where he thought it would help his business, and apparently he was correct, and he was operating very successful businesses by advertising the chicken as halal compliant. And the franchisor put a stop to that and said, I think after allowing it for a period of time, put a stop to it and said that that marketing practice was not allowed under the franchise agreement. The franchise agreement gave the franchisor the right to review in advance all advertising, and they did have to have that honored, and the franchisee could not advertise in a way that the franchisor did not like. So that ended up being a victory for the franchisor. The franchisee lost the case that was brought against KFC. The lawsuit was unsuccessful. So again, it comes down to the general principle of the contracts really determine the outcome of all of these cases. So with that, that is a rundown of what we found to be the most interesting cases in 2018. If you have any questions, but having seen none so far, unless you type real fast and get it into us by the time I say goodbye, we will close it off at this point, and thank you for attending our webinar.